to the second chapter meeting of the Trinidad and Tobago chapter of the Institute of Internal Auditors. I'll let our president, Mr. Sunil Babaram, give his introduction before we begin.
Hi, good morning, and it's always good to be part of the chapter. Thank you all for attending, and my name is Sunil Babaram. I am the president for the Trinidad and Tobago chapter. And just a couple of quick announcements. We have added some exciting and new stuff into our quarterly magazine. So please, if you haven't looked at it yet, take a minute, browse through, read. You might find some interesting articles in there. Look out for a training session on corporate governance entitled How to Maintain Effective Governance During the Pandemic, where we're tying in corporate governance and the impact that this has on the pandemic and the corporate governance linking each other there. And also look out for a membership meeting that we have carded for August, right, where we will present the financial statement and have the membership approve some other documents. So Justin Smith, as you're seeing there, is our government relation officer. He's also a senior manager with the central bank, senior internal auditor with the central bank. So I now hand it over to him. Justin will be the one who's running all the chapter meeting from now on. So Justin, out to you.
All right, thanks, Sunil. Okay, and thanks everyone for joining us today. All right, today's course, which is always very topical, will discuss the Public Procurement and Disposal of Public Property Act 2015, its amendments, and the attendant regulations. The course will provide an overview of the procurement legislation, the new changes and how they affect companies and entities, the system and procedures that companies would need to effect for the legislation, and the role of internal audit in this new procurement framework. And to present all of this, we have the privilege of three very qualified and experienced facilitators. Mr. Moonilal Lalchan, who is the chairman and procurement regulator of the Procurement Board of Trinidad and Tobago. Mr. Lalchan served on the Board of Governors and was also chairman of the Audit Committee of the National Energy Skills Center and chairman of the Board of Directors of Invest TT Limited and the Education Facilities Companies Limited. Mr. Moonilal is a former director and vice president, finance and planning of Atlantic LNG, and a former director of the Hotel Facilitation Company Limited and several REC financial institutions. He's also a past president of the Trinidad and Tobago Chamber of Industry and Commerce. Mr. Moonilal is a fellow of the Chartered Association of Certified Accountants and has an EMBA from Auburn University and the Advanced Management Program of Harvard Business School. With him, we'll also have Ms. Delrene Liverpool-Young, who serves as the corporate secretary to the Procurement Board of Trinidad and Tobago. She leads the organization's corporate governance and compliance function and provides legal advice to its board, committee, and senior management. Delrene has a background in policy drafting and has co-authored numerous research papers. Ms. Liverpool-Young has experience in public interest law, real property law, and criminal law that she has gained from her time at the Office of the Parliament of the Republic of Trinidad and Tobago, the Ministry of Water, Land, Environment, and Climate Change in Jamaica, and law chambers both here and in the US. She has also served as the president of the Student Rep Council at Hugh Wooding Law School, in-country legal researcher of the International Development Law Organization, and is an International Affairs Chairperson of the Cave Hill Campus Guild of Students. She's currently the head of the esteemed legal team of the Organization for Abused and Battered Individuals. And we would also have Ms. Sharda Nanan, who is the team lead, Audit and Investigation at the Office of Procurement Regulation. Ms. Nanan has over 15 years of experience in internal audit, risk evaluation, and global banking, with experience spanning companies such as RBTT Financial, Caribbean Finance Group, and EMA. Ms. Nanan is also ACCA qualified, has a BSc in Management, and a diploma in Forensic Accounting and Fraud Detection. She's also a certified internal auditor and a forensic certified public accountant. So we see here that we have a wealth of experience among our presenters today, and I'd really urge us all to take advantage of this opportunity to interact with them and generate some constructive discussion around the topic, and to, really just get the best benefit that we can from this presentation. And so I'll now hand you over to their capable hands for the next few hours. If you're having problems with your sound and you'd like to ask questions, as always, you could always use the chat option, and I will try to, I can read your questions if it comes up when we have the opportunity. All right, so without anything further, I'll hand you over to the team for their presentation.
In an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015, which seeks to promote sustainable procurement practices within our public sector. So, as we acquire goods, works and services, sustainable procurement is our collective decision to choose energy-efficient equipment, eco-friendly products, ethically produced and fair trade products, equal tender opportunities for local and small suppliers. Just one new responsible action today can make a huge impact for sustainable results. To find out more about how you could implement sustainable procurement practices, visit the resources section of our website, oprtt.org.
Thank you very much, Justin, and a very good morning to all the participants this morning. And it's our privilege to be sharing once again with the membership of the Institute of Internal Auditors. And I'm always happy to be part of this forum, being a member, a very old member of the Institute of Internal Auditors. You probably wouldn't even see my name again on the list of members, but always willing to share. And in addition to Delrene and Sharda, we do have in the room with us two other persons, and that's our Deputy Chairman, Robbie Bola, and my Executive Assistant, Stacia Marbia, and they are going to be with us for the entire duration of the session. So again, welcome, and for those who would have participated in the first session, some of the information that we'll be sharing would be some repeat slides. But we are going into a number of new areas in terms of the amendment to the Act, and then the whole issue of the role of the internal audit department as we look at the public procurement regime. So without further delay, we'll go straight into our presentation. And as Justin would have mentioned, if you have any questions, feel free to put it in the chat, and at the end of the session, we'll answer as many of those questions as possible. And we will also allow you the opportunity, if you wish, to actually ask the questions verbally as we go through. So what's all this hype about public procurement? Why do we need proper legislation? What gave rise to these new legislation in 2015? What's the background data and so on? Now, there was a study that was done by the Organization for Economic Cooperation and Development, and that was done in 2014. And that study confirmed that public procurement is one of the government's activities most vulnerable to corruption. And if you live in Trinidad, you will probably be nodding your head right now and saying they couldn't be far out from the truth. And it's just because of the volume of transaction. And in their study, they suggested that 2/3 of foreign bribery cases occurred in sector closely associated with contracts or licensing through public procurement. And if done correctly, between 10 and 30% of the investment in publicly funded construction projects may be lost due to mismanagement and corruption. And we did some back of the envelope calculation. We suggested, let's say, 20% of that is lost. in a budget of $52 billion, where $26 billion will probably be associated with public procurement, and this is on the low side, we can, if we extrapolate, 20% of that is about $5.2 billion. So in a sense, think about what we can do with $5.2 billion every year in terms of potential savings as it relates to corruption and so on. That could run the country every 5 years in terms of public procurement. So that's the prize we after. And then there was a similar study done in, by the European Commission. And this study suggested that approximately euro 120 billion are lost. So, you know, you can beat up on ourselves in Trinidad and say, well, we are so corrupt and so on. But this shows that even in the European countries where we're supposed to have all these good systems and processes and so on, a substantial amount of money is lost every year, 120 billion euro. And this, they slice it up and say, let's study and see where those areas of inefficiencies are. And one of the major areas, accounting for about 48%, is the lack of adequate capability and management of the procurement functions. And this is where we believe the whole issue of governance and management comes in, especially as it relates to the role of the Internal Audit Department in really helping management and the board in fulfilling its mandate. So as we go through this morning's presentation, just keep that to the back of our minds. So what is the OPR? The OPR, or the Office of Procurement Regulation, the office was established by the Public Procurement and Disposal of Public Property Act 2015 as amended. And we are a regulatory body governed by an independent board, and that is very important. And internal auditors would understand what's the real significance of being independent in terms of your mandate. We were appointed by the President after the consultation with the Prime Minister and Leader of the Opposition. The first board was actually appointed on January 12, 2018, just about 3.5 years ago. And it comprises 11 members, including the Chairman, Procurement Regulator, and the Deputy Chairman. So we have 11 members, and right now we have, after the appointment of the Deputy Chairman, we are up to 10 now. So we are just waiting for one more person because of the rotation every 3 years. And our independence is made clear in Section 13(2)(b) of the Act. And it says that we should not be subject to the direction or control of any person or authority in the performance of our function, but shall be accountable to Parliament. In fact, all our report goes to the Speaker of the House, with a copy to the President of the Senate, and a copy to the Minister of Finance in his capacity as corporation sole. So what are some of the principles under which we operate? So the objects of the Act under Section 5 enunciates a number of principles. One, accountability. Most people will be aware of these 4 principles because it's often being talked about. Anytime we talk about the OPR, we talk about accountability, integrity, transparency, and value for money. But the principles and the objects goes further in terms of efficiency, fairness, equity, public confidence, local industry development, sustainable procurement. You would have heard the clip in terms of sustainable procurement and sustainable development. So all those are working together in terms of the expectation in fulfilling the objects of the Act. The functions of the office under Section 13 are one, and as I go through these, I'll take the opportunity at the same time to give you an update in terms of where we are for every one of these functions of the Act. To establish a comprehensive database of tenders and awarded contracts, that has been completed. The database is up and running. User ID and passwords have been given out to members of the public bodies, namely the accounting officers and the named procurement officers. And this really has to do with the reporting of the award of contracts and tenders. So now on a quarterly basis, 21 days after the month or the quarter, every public body is required to report on the database all the contracts awarded, tenders and contracts, to whom it was awarded, the value of those contracts, the amount paid to date, the amount outstanding, and any variation orders, and any such information as the office may think that is necessary for the public consumption. So that's completed. We are ready to get that information. In fact, some public bodies have already started sending in their information, not only database, but through Excel spreadsheets and so on. So that is ready. To set training standards, competency levels, and certification requirements, we have been working with the Accreditation Council of Trinidad and Tobago and some of the learning institutions to develop this. This is also completed. And if you want to have a copy of it, it is on our website. So that's completed. To issue guidelines on the retention and disposal of public property, that is already completed. And I'll mention a change to section 13.10 in terms of what was amended in December of last year. So those guidelines have been completed. You can find them on our website. To prepare model handbooks with standardized bidding documents, those we would have completed 41 of those, and they are in now final format, and they can be found on our website. And a little later, Sharda will go through those 41 in summary as to where you will find them and so completed. Promote the use of technology in procurement and disposal. We have been working with a number of organizations, also the Ministry of Finance, in terms of looking at possible solution in terms of technology. We have developed some short-term measures in terms of the use of technology. During the pandemic, a number of the ministries are already using it in terms of how you can use technology. You don't have to drop your bids and so on in these big boxes and so that has been completed also. But the mainstay in terms of using an e-procurement platform is work in progress that we will be shortly entering into. To harmonize policy systems and practices. What we found out when we took up our office is that as many as you have public bodies, you have different policies, systems, and practices. So what we have sought to do in our handbooks and guidelines is to harmonize those policies, systems, and practices. And by putting together like standard forms, standard contracts, and so on, all those have been completed. To promote public awareness, we would have done over 235 sessions, including this one. This might be about 236 or 237, in terms of chambers of commerce, business organization, manufacturers association, contractors association, Rotary clubs, educational establishments, a whole host of different public bodies. All those is in keeping with promoting public awareness, and we would have gotten a lot of feedback when we were preparing our handbooks and guidelines and our regulations from these public awareness sessions. To review practices and delivery system on an annual basis, this is about continuous learning. And we would not be restricted to just an annual basis. In fact, we will be doing this as an ongoing basis and at least on an annual basis, but this is something that we have already started. To act for the state of disposal of real property is contained or was contained in section 13.10. What that would have done is to give us the authority to dispose of real property. And we thought as an organization, this is clearly a conflict because 13.1N gives us the authority to investigate on our own behalf or on report from any member of the public and so on. And we believe that if we are involved in disposal, we should not be involved in investigating those disposals. So we asked the government to rethink that. They have thought it over and they have now taken it out of the act. Our recommendation is that another public body should be given the mandate to dispose of these real property. We are awaiting the regulations for this that should be prepared by the Ministry of Finance for submission to Parliament. To advise on best practice to obtain value for money. Again, we have been, so far, we would have probably responded to over 500 queries. Over 600 now queries in terms of how do I do procurement and so on. And it's all about a change in focus because previously, and this is one of the areas that the internal auditors could help us with. Previously, you would put down these huge buildings, very expensive, buy very expensive pieces of equipment, and you don't have a plan in terms of maintenance. You don't consider the full value and the full cost. So you run things to failure, and then the cost associated with run to failure is a lot more than if you take the necessary care and attention at the onset in your planning activities, which we'll be discussing later, to look at the full value costs and make sure that you have proper maintenance contracts and so on. It saves you a lot of money in the long term. So that's an area that we have been advising on. And then to audit and review the systems of procurement and disposal to ensure that there is compliance with the objects of the Act. So we have a role to audit and also investigate on our own initiative or upon complaint from any party involved in public procurement or disposal of public property or any member of the public, any alleged or suspected breach of the Act. And therefore, we have a full-time engaged department headed by Sharda that deals with both audit and investigation. And there is a process to be followed after an audit, after an investigation, in terms of taking it straight through the court system via the DPP for making sure that if somebody is found culpable in terms of breaches, and there are several breaches, we go through those also, that you can be significantly charged in terms of jail terms and so on. So that's where we are in terms of the requirements, what we are required as the OPR. And therefore, the question is, who falls under the Act? And this is very broad-based. The Office of the President, that's the President of the Republic, and they have been very, very good in terms of compliance so far. The Parliament, the Judiciary. So even though some of our cases will go before the Judiciary, they are also required to make sure that they are in compliance with the Act. A Ministry or Department or Division, Tobago House of Assembly, municipal corporations, regional health authorities, statutory bodies, state-controlled enterprises, service commissions, and then a body corporate or unincorporated entity using public money, which is even broader in its perspective than what was previously just seen. And that is anybody who uses public money and gets this subvention from any public body that is registered above. And public money means received or receivable by a public body, raised by an instrument from which it can be reasonably inferred that the state accepts ultimate liability in the case of default, for example, the raising of bonds and so on, where the government gives these, you know, they stand security and they say, if you fail, we will pay. So that is public money, spent or committed for future expenditure by a public body, distributed by a public body to a person. So if you take, for example, Ministry of Education, all these schools that they support, the denominational schools and so on, and that money is used for public procurement. Sports, TT, under the Ministry of Sports, all the subvention for sporting organization, whether it's cricket, football, lawn tennis, table tennis, they all fall under the Act. Raised in accordance with a written law for a public purpose or appropriated by Parliament. So you can see this is very wide ranging. So whereas we probably have about 345 direct public bodies, you have thousands of indirect public bodies that use public money. Who is responsible for procurement? And this has engaged a lot of attention, especially from boards of directors and also subcommittees of the board who has been mandated to do tenders, these subcommittee or the tender subcommittee of boards. But the Act is very clear. It says under section 61(2) that a public body shall, and those who practice law will know shall mean shall and nothing else. A body shall have a procurement officer who shall be responsible for public procurement and the disposal of public property. There is no ambiguity with that for that body, and shall notify the office in writing of the name and designation of its procurement officer. Why? Because a reference in this Act to the commission of an offense by a public body shall be construed as a reference to the commission of the offense by the procurement officer referred to in subsection 2, or an officer who purports to act in such a capacity. So if an officer like the board of directors or somebody outside of the purview of the procurement officer or the accounting officer decides that they want to take up that responsibility, nothing in the act stops them from doing it. But it tells you clearly that you will be held liable, and if the offense is proven that the offense was committed with that person's direct consent or connivance, or that person with knowledge did not exercise reasonable diligence to prevent the commission of the offense. And I can guarantee you the charges and the fines are very substantial. So this is a diagram we actually put together to guide the accounting officer CEOs, the internal audit departments, the assurance committee or audit committee of the board, in terms of how this all fits together. So we do have a disposal committee who deals with disposal, and we are recommending that at a minimum 3 to 6 persons, 3 at the minimum, 6 at the maximum. You're supposed to have like the asset manager, inventory officer, and a subject matter expert forming that committee. And then you have the evaluation committee that also we suggest minimum 3, maximum 6. That will include like the procurement officer, legal person, and user department personnel in the constitution of that evaluation committee, which is a very important committee. And we have been asked on several occasions that whether or not members of the board with the necessary technical experience should form part of that evaluation committee. And we are saying, be careful, stay away from that. In fact, recently in 2017, there was a memorandum in Jamaica that went out from the Ministry of Finance debarring any member of any board from participating in the evaluation committee of those state enterprises and government ministries. And I think the intention in our act was similar to that in Jamaica. So then we have these two evaluation committee and disposal committee, because of 61, now being responsible to the named procurement officer. And the named procurement officer is the one who coordinates the activities. And we are now recommended a PDAC, and the PDAC is the Procurement and Disposal Advisory Committee. So it's not an approval committee, but it's a committee there to advise the accounting officer or the CEO, who is ultimately accountable, not responsible, but accountable. Responsibility is the named procurement officer. Accountable is the accounting officer or the CEO. And we are suggesting, as part of that committee, the head of legal, head of finance, and a subject matter expert. The reason being, these are the persons who will be aware of what's taking place most likely in the organization. And once that recommendation comes to the PDAC, in the case of a disposal, you can accept or reject it. If you accept it, you go ahead and dispose. No longer you have to go through things like the Central Tenders Committee and so on, where that was required before. All that is done now within the public body. And if you're disagreeing at the accounting officer level, you disagree with the recommendation, you go back to the PDAC and ask them to relook it, and you still disagree, then you have to go and consult with your line minister, and this is included in the act, to determine the way forward. And once you have determined an alternate course of action, you now have to write a report to the office indicating why you have chosen that alternate course of action, and you must have it properly documented and substantiated as to why you take that course of action. In the high-risk, high-value disposal, we are recommending that you include the board, you see that dotted line there, for no objection. Not that they are approving it, but they are saying we have no concern, you can go ahead and do what you are recommending that you're doing. Similarly, in terms of the procurement, high-risk, high-value, or the ones that the board would like to be aware of in terms of what's taking place, you should keep them involved, and they have an opportunity to object to the award and state that these are our concerns. It must be properly documented in your procurement file. If you accept it, you go ahead and execute in accordance with the recommendation. If you reject, you return back to the evaluation committee through the PDAC for revisiting that. And at all times for the high risk, high value, you should include the board of directors. Let me also say at this point in time that you are required now to produce an annual procurement plan within 6 weeks of the approval of the national budget. And therefore that the approved plan comes to the office, our recommendation is that that plan must go through your board, because the board then decides in terms of the budget and the plan, and therefore the board will have a sight of those plans within that 6-week period, or even before you send it to the Ministry of Finance for inclusion in the budget. Once they are aware of the plan, is now to make sure that they monitor those plans as you go forward. So one of the things that we expect the audit function to do is to look at those plans and make sure it's in keeping with certain protocols in terms of your business plan, your strategic plan, and so on. And therefore, once that comes to the office, we look at it and then we'll continuously monitor it. What is required to be published? You are required to publish the list of procurement activities in the same time period in the, on your website, or if you choose to do it on the newspaper. Failure to produce that will be in breach of the Act, so you have to produce it. You shall produce that, and any member of the public could request a copy if they don't see it. So they can come to you and ask for a copy, and they pay whatever it costs to reproduce it. You can charge them for that. So that's how this is evolving. Some questions were raised in terms of what about some of these committees that have been established by the constitutional establishment of these organizations. Now, the Act is actually going to supersede some of those, and therefore there is an implied repeal of those sections of your respective documents, and therefore you must take the decision now to get them expressly repealed once they are in conflict with the Public Procurement and Disposal of Public Property Act. So I hope that clears it up. I'm sure there will be some questions at the end in terms of that. So at this time, I will just look at 2 other slides in terms of what are some of the powers of the office. Under section 6.1, any procurement of goods, works, or services, or retention or disposal of public property that is not done in accordance with the Act, and any procurement contract or agreement that is not entered into in accordance with this Act shall be void and illegal. So we do have the powers to make those things void and illegal. Of course, you will have redress through the different facilities and so on. But in the exercise of our function, we shall act expeditiously and take such other steps. And a number of organizations have been concerned in terms of how long it will take to have these procedures done and so on. Well, it is very, very time specific in terms of when we have to deal with these issues. And within 20 days, we have to make our decision in terms of some of these issues. So rest assured, we will be doing that. All right. And one of the facilities that is being available to both to the contractors and suppliers is our challenge proceedings. And I'll hand you over now to the legal experts in that area, Delrene Liverpool-Young, and she's going to take you through the next couple of slides.
Okay, good morning, everyone. It's a pleasure to be with you here this morning. So as Mr. Lalchan alluded to, the challenge proceeding is one mechanism by which information in respect of breach of the Public Procurement and Disposal of Public Property Act can come to the office. So what really is the challenge proceedings? Well, these are proceedings whereby suppliers or contractors who has a grievance against a public body can make that grievance known to the office. However, there are 2 hurdles that first must be crossed. And these are that a procuring entity would have taken a decision or took action that is not in compliance with this Act. And secondly, that the supplier or contractor must have suffered or is likely to suffer some loss or injury because of this decision or action. So once these 2 hurdles are met, a supplier or contractor now has what we say in law as in standi, locus standi. They now can bring an action before the OPR. So this notwithstanding, this application, however, is restricted in respect of time. So you really can only bring an application to challenge a decision of a procuring entity in certain circumstances. And these circumstances are in respect of in respect of solicitation or pre-qualification. So it would be at the stage where, you know, there is solicitation is now taking place, or pre-qualification or pre-selection. Secondly, applications for reviews. Secondly, application for reviews could come before the organization in respect of where an entity, in respect of a standstill period. That is the next time frame. And then what we're going into now is what exactly is a standstill period. Well, the standstill period is, next slide. Please bear with me one moment. I think I have some of my slides mixed up. Okay, I'll just follow from the screen instead. Yeah, right. So as I was saying, there are specific time frames in which suppliers or contractors can bring a claim before the Office of the Procurement Regulation. And in terms of the time frames, you could either bring it at the beginning in terms of where pre-qualification or pre-selection has taken place, or you could bring it within the standstill period. And the standstill period is, the definition of the standstill period is laid out in the interpretation section of the Act. And we will discuss the definition of the standstill period in a later slide. So what exactly is the standstill period? The standstill period is this period whereby a procuring entity cannot take any decisions in respect of a specific procurement. Another time frame is where there is no standstill period, you can bring an action before the Office of Procurement Regulation within 7 working days. And in what circumstances would there be no standstill period? Well, usually no standstill period would be applied in respect of emergency procurements. However, notwithstanding this, the regulations which support the Act, the OPR would have put in a minimum time frame in terms of standstill period. So there should be no circumstances where there is a zero standstill period. Now, in terms of section 53, this really speaks to the obligations of the Office of Procurement Regulation and what has to be done when the office receives a complaint from or a challenge from a supplier or contractor. So within 3 days of receiving an application for review, the office is mandated to publish a notice within the newspaper. And what is the purpose of publishing the notice within the newspaper? Well, this is to basically bring all members of the public and have all members of the public be aware of the fact that, you know, a particular supplier or contractor has an action against a particular public body. And another reason for this really is so that other suppliers and contractors who may have been or suffered a similar breach by the same procuring entity may be able to join that challenge with the supplier or contractor bringing the action. So in the interim, what can the office do before a decision is taken? So we're not talking about as yet the point whereby once the office receives the application is adjudicated upon. We're talking about prior to that. So the office has certain powers prior to even a final decision is taken. And section 54 basically outlines, you know, the powers, the wide powers of the office. And some of these powers include, and of course, these will be, the regulator will exercise these powers on a case-by-case basis. These include the suspension of procurement proceedings at any time before the entry into force of a procurement contract. So at any time, so once a procurement has been done by a public body, procurement activities have been started or commenced by a public body, and a supplier or contractor brings a complaint. Depending on where the procurement activity has reached, the office can order the suspension of that procurement process. Another power of the office is also the suspension of the performance of a procurement contract or the operation of a framework agreement that has entered into force. So the power under Section B really speaks to a situation where you have a contract that has already been executed. So you would imagine that those powers are wide powers. And as the showseo of the legislation states, the procurement regulator can exercise these powers and order, the suspension of either the procurement proceedings or the performance of a contract, so long as he finds it necessary for the suspension to protect the interests of the applicant. So earlier on, I would have alluded to the standstill period. And I would have spoken to the meaning of the standstill period. So the definition of the standstill period could be found within the interpretation section of the Act, which is Section 4. And it stipulates that a standstill period means the period from the dispatch of a notice as required by Section 35, during which a procuring entity cannot accept the successful submission and suppliers or contractors can challenge the decision to notify. So I know you may not be aware of what Section 35 says, but Section 35 basically notes that a procuring entity shall notify each supplier or contractor who presented submissions, and by presented submissions we mean each supplier or contractor who would have tendered its decision to accept the successful submission at the end of the standstill period. So effectively what this is saying is where a supplier or contractor would have tendered for a particular procurement and would have perhaps won a particular procurement, the procuring entity has an obligation to notify all suppliers and contractors of its intention to award a particular contract to the supplier or contractor that would have won. And at that point, that notice is dispatched. During the period where that first notice is dispatched, that is the period in which the supplier or contractor has now some latitude to bring an application to the OPR. So we move on now to Section 35(4), which states that subsection 2, which is the decision above, shall not apply to awards of procurement contracts where procurement entity determines that urgent public interest considerations requires the procurement to proceed without a standstill period. And as I would have alluded to before, where procurement would proceed without a standstill period, we're looking at emergency circumstances. And when we say emergency, we mean circumstances in respect of life and limb. So, Mr. Lalchan would have alluded to before, under Section 13, that the office would have set up a database. Now, under Section 26, so the procurement depository and the database actually I like to call it a twin database. So effectively, they work hand in hand. So the procurement depository is really like a data dump, for want of a better phrase, so that suppliers and contractors may come onto the depository and enter their information in terms of, the nature of the business, upload information in respect of NIS, and upload information in respect of their qualifications and their certifications. And once that has been uploaded and it has been verified on the OPR's end, once we sanitize that list, it's a simple switch where we can deem that person to be pre-qualified once all of their documents have been verified and are in order. And then you will now be on under Section 13, the database of pre-qualified suppliers and contractors. Now, this notwithstanding, you should know that the procurement depository is accessible to all members of the public. So whatever information you upload on the procurement depository side of things, except confidential information, would be, the members of the public would be able to view that side of the database. Another thing that should be noted is that the supplier or contractor is the person responsible, or is the entity that is responsible for ensuring the accuracy of the information. So there's a burden placed on suppliers and contractors to ensure that the information that they would have uploaded is accurate. Now, a procuring entity also has a burden placed on them, and their burden could be found in section 29(1) of the Act. And we call this section the due diligence section of the Act, because it speaks to a situation where the procuring entity is the one that may require the supplier or contractor who has submitted information to the procurement depository to confirm the accuracy of the information submitted. And this is very important, because where you submit information that is inaccurate, or where a supplier or contractor submits information that is inaccurate, a supplier or contractor may be disqualified from participating in procurement proceedings under the section 29. Now, we now move to pre-qualification. And under the interpretation section of the Act again, what is pre-qualification? Well, pre-qualification is essentially the procedure to identify, prior to solicitation, suppliers and contractors who are qualified. Qualified meaning qualified to participate in the procurement proceedings. And how does a supplier or how does a procuring entity ensure that suppliers and contractors are qualified? Well, under the Act, it says that procuring entities or public bodies need to ensure that contractors have legal capacity to enter into a procurement contract. And every time I reach to this point, I'm reminding of an example where a particular ministry had entered into an agreement with a particular supplier contractor, and when the due diligence, the contract was executed and monies were paid to the particular supplier and contractor. However, work had not been completed, and the supplier and contractor would have left the country, absconded with the ministry's money. And when the investigation began, what they realized was that the directors of this particular entity were minors. So when they checked the company's registry, the directors were 8 years old, 9 years old. So if they would have done proper due diligence prior to executing the contract, they would have recognized that the particular supplier, contractor / entity would not have had the legal capacity to enter into these into this particular procurement proceedings. Another obligation is on the procuring entity is to ensure that the particular supplier contractor is not insolvent, is not in receivership, the affairs of the company is not being administered by a court, etc. So there has been an amendment to, so this is the old section 29(1). Under the Act number 5 of 2015, which is the parent legislation, and I will just stick a pin here to say that the Public Procurement and Disposal of Public Property Act 2015 has been amended 4 times. It would have been amended in 2016, 2017, amended 3 times. It would have been amended in 2016, 2017, and more recently, 2020. And under the amendment, which we will get into later, but I will just, draw it to your attention here now, this section 29(1)(c) has now been expanded, and it has been expanded to include as follows. A procuring entity shall ensure that suppliers and contractors have not been convicted within the past 10 years of corruption or fraud-related offenses locally or internationally. So what it did was basically stipulate the time frame in which entities should look at convictions. Because what's this, and this was a recommendation of the OPR to the Legislative Review Committee of Cabinet. We felt that this section on the screen, section 29(1)(c), was a bit too wide. And so, for example, have not, and their directors or officers have not been convicted of any criminal offense. What is any criminal offense? A criminal offense could be a road traffic offense. because road traffic offenses fall under the criminal jurisdiction. So effectively, what the legislation would have been saying is, if a director or an officer of the company would have had a ticket or would have been convicted of some road traffic offense, then that person would not have been able to participate in procurement proceedings with a public body, right? So because of that because it was so wide, we decided to seek an amendment, and this was the amendment given. So we will now move on to the latter part of the section, and this section really speaks to other obligations of the procuring entity. The procuring entity shall also ensure that, whoever supplier or contractor they're engaging, that those persons have the necessary professional and technical qualifications, as well as competence, financial resources, equipment, and other physical facilities, managerial capability, etc. In terms of F, meet the relevant industry standards. And that, I think, speaks for itself. So we will now move on to the ineligibility list. And what really is the ineligibility list? The ineligibility list is what is known in the international sphere as a debarment list or a blacklist. It's similar to a debarment list or a blacklist. And Section 58 speaks to the ineligibility list. And as the slide says, it is a list of suppliers or contractors who shall not participate in procurement proceedings. And how do you determine whether or not a supplier or contractor shall not participate in procurement proceedings? Well, the legislation speaks to how the office may add a supplier or contractor to such a list, and the reasons why a supplier or contractor should be added to the list. And some of these reasons include where the supplier or contractor consistently fails to provide satisfactory performance, is found to be indulging in corrupt or fraudulent practices, or is committed of an offense under this act. And a lot of persons from our stakeholder engagements have said, well, these are such, wide criteria. What does it mean in terms of, found to be indulging in corrupt or fraudulent practices, or, consistently fails to provide satisfactory performance? And what we've done as the office is we would have included in our draft regulations in the subsidiary legislation to support the act mechanisms to treat with these. And I will also stick up in here to say that the ineligibility regulations would have been one of the regulations laid before Parliament on the 2nd of July, and it's available for review on our website, on our OPR website. Additionally, the office would have developed a mechanism whereby suppliers or contractors would be accorded an adequate opportunity to be heard and to make representation before that particular supplier or contractor is added to the ineligibility list pursuant to this section. And what is interesting about the term and the definition of supplier and contractor, specifically under this section, is how wide it is. A supplier or contractor includes any person who is a director, manager, senior officer, partner, or other similar officer, or any person who purports to act in such capacity. And I like the latter line there, because it says any person who purports to act in such capacity. So even if you're not employed with an organization in the capacity of a senior officer, but you are exhibiting behavior and direction and control, you could be deemed to be purporting to act in such a capacity. And it goes further when you look at what is the definition of a senior officer. And as Mr. Lalchan likes to say, it's everybody except the T person, except the T lady, right? Because a senior officer means a managing director, a CEO, a COO, a deputy managing director, the president, the vice president, the secretary, the treasurer, the chief financial officer, financial controller. Everyone is mentioned: the deputy general manager, the corporate secretary, the chief accountant, the chief auditor, the chief investment officer, So the definition of the term itself in terms of who could be added to the ineligibility list is wide. And if you go to section 58, you will see that it is a supplier or contractor that shall not participate in procurement proceedings. So what this section effectively does is it removes a scenario whereby, let's say, Bola and Associates participates in a procurement proceedings, and then the directors of Bola and Associates, after they've been added to the ineligibility list, says to themselves, well, okay, Bola and Associates has been added to the ineligibility list, and we can't transact business with government. So what should we do? Well, let's go and create another company, right? A scenario like that would not happen because the definition of a supplier or contractor includes the persons themselves. So I always like to make stakeholders aware of this. So I would have mentioned before that the legislation would have been amended on 3 separate occasions. In 2016, and in 2016, the amendments to the legislation would have dealt with disposal of public property, among other things, in terms of real property also. State lands, land owned by lands and real property owned by public bodies, statutory authorities, etc. And it also made provisions for the review board, which is a board that has been established to review the decisions of the office in relation to challenge proceedings. In 2017, the legislation was also amended, and in 2017, that particular piece of legislation made the amendments were in relation to the term of office of the board members of the OPR, as well as the salaries for the members of the board. And more recently, the legislation would have been amended in 2020. And what we're going to look at now would be some of the key features of the 2020 amendment. And this amendment is known as Act number 27 of 2020. And some of the key features of this piece of legislation really, well, there are 7 main features, and it really speaks to the definition of bid rigging. We're going to look at section 7.2 and 7.3, which speaks to government-to-government arrangements, as well as private-public partnerships. Third feature, disposal of public property, due diligence in terms of criminal offenses, which I would have touched on a little bit before when I would have discussed prequalification. The time of the decision of an action, a review of an action of the OPR, conduct influencing public officers and what that entails, and options available to public officers. I wouldn't delve too much into options available to public officers, however. So in terms of bid rigging, what was the amendment? Well, the definition of bid rigging has now been widened to come more in alignment with other pieces of legislation that we have in Trinidad and Tobago. So for example, the Fair Trading Act and the Fair Trading legislation speaks to competition in the marketplace. So you're looking at preventing scenarios in terms of where there is monopolization of the market. So in the old legislation, collusion, and another thing to note here was under the old legislation didn't form an offense, a criminal offense. So what we did was we made a recommendation to actually make bid rigging an offense under the law of Trinidad and Tobago. So under the old legislation, it would have said collusion between persons for the purpose of manipulating proceedings. And what I mean by it wasn't an offense in law. So the terminology was too wide, because effectively collusion between persons, if you take it on the low end of things, it could have meant I am speaking to my friend about how we could win a contract, and that in effect was not an offense in law. So now it has been amended to, is a little bit more specific: collusive price fixing and anti-competitive behavior, which is designed to unfairly influence the outcome of a competitive tender process in favor of one or more bidders. And this definition is more in line with is more in line with the international definitions. So when you look at jurisdictions such as Canada, the United Kingdom, Kenya, and jurisdictions where there's procurement legislation, there's also case law to support this particular definition. In terms of the Second Amendment speaks to Section 7(2) of the Act. So the following wording in red is what was deleted. So under the old legislation, where there was any form of conflict between obligations of the state, meaning the state of Trinidad and Tobago, and any other, treaty or agreement, international treaty, or any agreement entered into the government of Trinidad and Tobago with a financing institution, and we know our government has a number of agreements with such institutions, or any agreement in terms of technical or other cooperation between the government of Trinidad and Tobago and the government of a foreign state, what the legislation would have said was that the requirements of the treaty shall prevail, except that the procurement of goods, works, and services shall be governed by this act. So where there was conflict before, while all the other provisions of the particular agreement would have prevailed, if there was procurement to be done under that particular agreement, it should have been done in accordance with our local Public Procurement and Disposal of Public Property Act. However, with the 2020 amendment, that has been removed altogether. So effectively, procurement will now be done in accordance with the provisions of the treaty or agreement entered into. That is, for example, if Trinidad and Tobago were to enter into an agreement with the government of New Zealand, and that particular agreement spoke to how procurement should be done, then procurement would be done in accordance with that agreement between the government, and not in relation to, and not under our local legislation. Another amendment was that this section above no longer applies to reports related to national security. So before, and I will read the section, a procuring entity engaged in procurement proceedings relating to a treaty or agreement referred to in the subsection 2A, which is the subsection in relation to treaty or agreements by which Trinidad and Tobago is a party to, they would have usually have to submit a report on compliance to the Office of Procurement Regulation to let us know, well, here what, I would have complied with Section 29. However, this scenario no longer applies to reports related to national security. So any procurement in relation to national security, the office would not be privy to reports on same. The Act, we call this section the disapplicability of the Act, because the Act no longer applies to procurement of legal services, procurement of debt financing services for the national budget, accounting and auditing services, medical emergency or other scheduled medical services, or any other such services as the minister may by order determine. Now, these types of services would have fallen under the Act before, but because of the new amendment, it no longer, procurement of these services no longer has to follow the Section 29 that I would have spoken about before, the due diligence section, or any part of the legislation. However, the amendment said that the minister would submit to the office guidelines, annual guidelines on a yearly basis, outlines under which these exempted circumstances are to be procured. So it is now up to the Ministry of Finance to say to the Office of Procurement Regulation, well, legal services is no longer the Act, but this is how the public bodies would be procuring legal services. This is the process by which we will go through for the procurement of, for example, accounting and auditing services. In terms of disposal of public property, well, this was a recommendation of the OPR. And the reason the OPR, so the deletion of this section, that is, so this section was deleted. Section 13.10, it says to act for, in the name and on behalf of the state, to dispose of real property owned by government in such a manner as the government may consider appropriate and desirable. And the OPR recommended this section to be deleted because the OPR felt it was a conflict of interest for the OPR to be acting as a rubber stamp, because it says in any manner in which the government may consider appropriate or desirable. And the reason really is, if the OPR is the oversight body responsible for investigating how disposal of public property, which includes real property, should be done, then we cannot, on the other hand, be executing contracts or disposals on behalf of the government in any manner as they may deem appropriate or desirable. And so that section was removed. Now, I would have spoken to section 29(1)(c) before, so I wouldn't spend any time on this section, on this slide. In terms of time of the decision after the review, now you would recall that I would have spoken about challenge proceedings. And what were challenge proceedings? Challenge proceedings will the opportunity that a supplier contractor has to bring a complaint against a procuring entity that would have breached an act. So once the OPR would have received an application, the OPR would then have 20 days in which to render a decision, right? And thereafter, once we render an oral decision, we would have an additional 20 days to reduce that decision to writing. Now, what has changed with the Amendment Act is that after we render the decision within 20 days, right, we now have 30 days in which to reduce our decision to writing. And that is effectively what the section does. In terms of the section that deals with conduct influencing the public officer, so if you were to go to the Parent Act under section 59, the Parent Act speaks to issuing of bribes to public bodies, or even, for example, offering gifts, or any conduct that would, any conduct by a supplier or contractor that would seek to give an advantage to himself or herself as a supplier or contractor. And the definition of relative in particular is what has been widened. So the definition has been widened to take into consideration our local and cultural situation, which speaks to the Cohabitational Relationships Act. And what is the Cohabitational Relationship Act? Well, it is just a common law union. So so it widens the definition of spouse and relative to include a common law union, which is what we deem in law a union other than marriage. So if you and someone else, as we like to say locally, shacking up, then if that person exhibits certain activity or tries to win favor of a procuring entity on your behalf, then that person is also covered. And lastly, in relation to the amendment to the 2020, the 2020 amendments would be options available to public officers. Now, these options available to public officers really take into consideration a situation where it really refers to public officers of the Central Tenders Board. Because once the Public Procurement and Disposal of Public Property Act comes into force and is fully proclaimed, then the Central Tenders Board would effectively be repealed and goes away. So the act catered for a transition mode for officers employed with the Central Tenders Board, and it gave them options to either come across to the the Office of Procurement Regulation. And the Act specifically outlines within the schedule the particular positions under the Central Tenders Board. So the section formally would have said, this section applies to an officer who on the date of assent of the Act, and the distinction really is, the distinction in terms of assent really has to do with when the legislation commenced. So in law, we say that the Public Procurement and Disposal of Public Property Act is partially proclaimed. And what that means is that some of the sections are enforced and some of the sections are not enforced. So until all of the sections are enforced and the Central Tenders Board Act has been repealed, then these options will become available to public officers employed with the Central Tenders Board. So now I will just briefly speak to you on the subsidiary legislation, more commonly known as the regulations. Now, there's been a lot of talk about the regulations or draft regulations to support, this Public Procurement and Disposal of Public Property Act. And 10 of these pieces of subsidiary legislation, 10 pieces of regulations will have been laid in the House of Representatives on July 2nd, 2021. What should be noted about these regulations is that these regulations are subject to the affirmative resolution of the House. And what does that mean? It simply means that these regulations must be debated. So it must pass through both the lower house as well as the upper house. So it must pass through the House of Representatives and be debated at that stage, and also thereafter pass through the Senate in the event that any amendments to the same needs to be made. Right, so those regulations were laid on July 2nd, 2021, and we have a note here that it will be debated at a later date. And this really was on the instruction of the Minister of Finance. And it would be debated at a later date because Parliament would soon be going on recess. So in terms of the legislative agenda, we have been informed that that would be the reason for the debate at a later date. As I said before, the 10 pieces of subsidiary legislation, regulations are available in two places. They are available on the OPR's website, and they can be downloaded, and they're also available on the Office of the Parliament's website. They're open for public comment and feedback, and you could submit your public comments to either the Office of the Parliament directly, or you could submit it to the OPR, and then what the OPR will do will be to compile submissions of comments received, and we would ensure that the relevant ministry, which is the Ministry of Finance, is able to review those comments and perhaps take them into consideration. So what are the regulations? And I won't go through in detail, but I will just give you some highlights of what the regulations entail. So the first regulation is it really deals with participation in procurement, and it speaks to domestic preference, participation in joint ventures, etc. And it speaks to the procurement depository. The second regulation has been done to support the pre-qualification and pre-selection sections of the Act. And it speaks to, what are pre-qualification documents, how an invitation for pre-selection is done, how the assessment is done. We look at weighted evaluation criteria. So the regulation, another regulation is the procurement methods and procedures, which supplements and supports the legislation, and it speaks to how strategic procurement should be done, what is limited bidding, the process for limited bidding, the process in terms of this new legislative framework in terms of how request for quotation should be done. And it also speaks to when these particular procurement methods should be used. It expounds on the role of the Procurement and Disposal Advisory Committee, which I know Mr. Lalchan would have mentioned before, and it would provide for processes in terms of electronic reverse auctions. And very importantly, the procedures for single source selection is outlined within those regulations. And these are 3 other pieces of regulations. As I indicated before, 10 of the regulations were laid, specific regulations to support evaluation in terms of evaluation criteria, and those regulations reflect international best practice in terms of how you procure consultants, in terms of how, how submissions are received and what is the evaluation procedure, as well as how proceedings should be recorded. So under the parent legislation, keeping a record of proceedings is very important, because it is now an offense to say that as a public body that you don't have a record of procurement proceedings. So gone are the days where, for example, files would go missing or records will be burned to hide alleged mismanagement or alleged corruption. Other regulations include retention of public property and disposal of personal property, regulations to support the challenge proceedings, which I would have gone through, regulations also support the ineligibility proceedings, and a miscellaneous section that really speaks to how committee members to support committees of the board of the office should be selected. And those would bring me to the end of some of the regulations to support the Act. And I will now turn you over to my little colleague, Ms. Nanan, who will discuss with you functions of internal audit. Thank you.
Thank you, Delrene. Thank you, Mr. Lalchan. So good morning again, colleagues. Thank you for allowing us to share this time and space with you all to discuss the Act and to discuss some of the functions that the Internal Audit Department is now going to have as a result of this Act. So I will go through very briefly this morning what are the functions of the Act, but what I'd like to discuss a little bit in more detail, but by no means touching all aspects of it, is what are some of the things that the internal auditors should look at when they are looking at the procurement within the public bodies. So the first slide is to tell us what are the functions of the internal auditor. So the internal auditor is responsible for performing procedures that test the efficiency and the effectiveness of a company's internal controls that are placed by the board of directors. We have a professional duty to provide an unbiased and objective view. We must be independent from the operations we evaluate and report to the highest level within the organization. And most of us who are within the internal audit department will know that the reporting is normally to the audit committee or the audit committee chair. So some of the functions will include ongoing testing and monitoring, identifying risk and risk management, making recommendation and remediation, ensuring that there's a proper use of the funds, which we would normally refer to as public funds, and we must ensure that there's compliance in specific now, the Act, what we refer to as the Act. So what are public sector auditors required to do? They're required now to perform risk-based audits. What do we mean by risk-based auditing? So risk-based auditing, we really look at the assessment of what methodologies that link the internal auditing to an organization overall risk management framework. The auditor is also looking at the allocation of resources based on that risk assessment. So allocate resources based on the risk assessment is important that the internal audit activity to ensure that they include the resources that are sufficient to cover the needs of their engagement, but require the attention and the detail of the professional care that is due. They must be forward-looking. So no longer are internal auditors required to only look at past transactions. Auditors are now expected to provide a more forward-looking review of the world and insight that can add value to management and the board to seek an effective move to the organization. Auditors should not only help identify risks, but should present a forward-looking view of data and provide greater transparency. We should also embrace the new technology. What has become clear, especially during this pandemic, is that the internal audit profession, we're seeing unprecedented changes with accelerating change in technology, data, advanced analytics, and automation. Auditors should be real-time in that based on your internal audit charter or your internal audit charter should include where the internal auditors have direct access to personnel and records personnel. You must be able to go into an audit knowing that you have access to all the records that will allow you to look at that audit effectively and efficiently. And you must also be able to have access to the personnel who are responsible for the particular area, in this instance, the named procurement officer and the accounting officer. So what are some of the new obligations under the Act? So the internal auditor, again, you must be able to test your internal controls to identify a deficiency and make recommendation. This is nothing new, particularly to the internal audit function. You must assess your internal control. Again, it's nothing new to the internal audit function, but now you are looking at it from the perspective of assessing those controlled with the Procurement Act in mind. Filing system. You must implement an efficient filing system which ensures that the procurement, the disposal, and contract management records are maintained and readily available. And later down in the slide, you will see why that is important. You must provide internal audit reports to the accounting officer. So now the internal accounting officer is one of the persons who will be held responsible for procurement. And all reports should be sent to the accounting officer for their review, particularly those that require those that support a recommendation or require an action by the accounting officer. And you must follow the guidelines. So Delrene would have indicated, or Delrene would have given an outline of some of the legislations that the office has prepared. And internal auditors now play a role in ensuring that public bodies are in compliance with those legislation. So how does the internal auditor of a public body or the internal auditors help the OPR, or how do we partner with the OPR? So the internal auditors of public bodies must be the conduit between the OPR and the procuring entity to ensure compliance. They must provide the request and the report and information in a timely manner. They have an obligation of continuing learning of best practice in procurement, compliance monitoring, inquiring the rights of the OPR and the accounting officer of a procuring entity. Okay, so the next slide we want to speak about is the risk assessment. What are some of the factors that affect the risk assessment of an internal auditor? So we have political, and I think in public bodies more so, we would see that there is some level of political interference, or we may have political changes happening. So every 5 years we have the government may change, or we may have a new political party. But that shouldn't stop the audit function, in that after an audit is completed, regardless of if a political party changes, the internal audit role continues, in that your recommendation should be followed through. We look at the governance aspect in terms of what controls are in place, what policies, what practices that you have. Is the internal audit department supported by senior management and the board? What is the attitude of the auditor in terms of implementing what we normally refer to as management action plan? Is it that the auditors are simply just performing an audit because it is one of the actions on your audit plan and you have to complete it? Is it that at the end of it, when you prepare a management action plan, you ensure that management plan is followed through? It goes to senior management, you ensure that the management action plan, when management sets a time frame for completing that action, that the action is completed within the time frame that they say, and it's not just continuously being pushed back because it's easy. So you look at the track record to ensure that the internal auditor is following up with management. If it is that they are not, management is not taking the function seriously, you escalate it to the audit committee. The audit committee has a responsibility as well to escalate it to the board. The competence and the remit of the audit in terms of is there a limitation that is put by the board or senior management in terms of what the auditors can look at, in terms of what records you're allowed, who you can speak to, what files you have access to, and your financial or operational constraints in terms of If it is that you are conducting an audit and you do not have the necessary resources to do that audit, is it that you have the latitude to engage an expert? Is it that you are receiving the necessary training that you ought to have in terms of meeting requirements of new legislation that are being passed, or any new act that you have coming on board that you want to go to training to? You should be able to keep up to date with this. The procurement experience. In particular, when you're doing the procurement audit, we're saying that the internal auditor should have some level of procurement experience. Procurement experience meaning that even in these sessions, you're engaging with the OPR, you're reading up on the handbooks and the guidelines, you're engaging in some sort of training that makes you more up to date with what is happening in the current sphere. So in terms of the procurement, risk assessment, and management, management also plays a very important role in terms of this procurement process. So we say you must identify and recognize that those procurement that are high risk. When we are looking at procurement, we look at those that have high risk. In that high risk, we look at the controls that are in place for those procurement activities. We ensure that there is sufficient planning and preparation time. The auditors, not only should a procurement take place, if it is that we say we have an emergency procurement, that's something that's different. But if it is that we have procurement activities, as Mr. Lalchan would have indicated, the procurement plan is required to be completed of 6 weeks after the passage of the budget. So once that procurement plan is completed, that procurement plan shouldn't vary significantly. So the procurement officer knows each one of the activity that is going to take place on a quarterly basis, on an annual basis. So there should be proper planning. You must develop an approach to minimize the impact of risks. So again, because there's proper planning, you do your proper research in terms of your procurement activity. And you invite audit early in terms of if it is that you think that there are challenges that you may be encountering, you invite the internal audit department to come in and have a look at something that you may feel that is not going as it ought to have been. So we like to call this particular slide the house, the procurement house. And that at the OPR, we have developed a lot of handbooks and guidelines. And on our website, there are currently 41 handbooks and guidelines. So there's a lot of information that is available to the internal auditor in terms of if it is that you're uncertain about this act, what it is that you're required to do, how it is that you're required to audit a particular process. You may not have had to do an audit of a procurement before. So how are you going about doing it? So the OPR has developed various sections in terms of to make it easy for each person. We have the planning, the tendering, the evaluation of award, the contract management, and the retention and disposal. At the top of the house, we have the roof, where we have the comprehensive handbook and guidelines on procurement. We have basic procurement handbook, a practical guide, and then we have the preparation of special handbooks and guidelines for approval by the OPR. Then we have the foundation in terms of the framework for operational and internal control for procurement, the code of conduct, the sector-specific guidelines, and then we have developing procurement capacity, monitoring and managing and reporting on procurement. Within each one of these, what we call pillars, you'll have, if you're looking at the planning. So let's just say you were auditing the planning process. You can simply go onto the OPR's website and you can download that particular handbook and guideline. So these handbooks and guidelines are laid out in a very easy format for you to go to each particular section, and you can download the material that you require to audit the area that you're looking at. So from these slides, what I want to do is take you specifically through the auditing of the handbooks and guidelines, or what we would refer to as the guidelines that are used for procurement. So what are some of the things we will look at in the planning if we're doing a procurement activity? We will want, as the internal auditor, you'd want to verify a purchase requisition has been prepared. So each procurement activity requires you to ensure that a purchase requisition is completed by the relevant requisitioning department. You must identify the method that is used in terms of the procurement activity. Verify that the purchase requisition has a unique identifier number. And this is particularly important when it is that you're tracing back or you're doing your audit validation in terms of all of the activity must line up with this particular identifier number. Verify that funding was approved for each procurement activity. So when we spoke of the procurement plan will show the funding that is allocated for each particular activity. So no longer can procurement be switched in terms of, let's just say you have $500,000 allocated for repairs, and now you want to say, well, you want to purchase computers, and you just switch that activity. You can't just switch. Yes, the office will allow the procurement plan to be changed, but not significantly. There must be a justification for that change. In addition to that, no longer can suppliers or contractors be waiting, or no longer should suppliers and contractors be waiting for payments. This is a common problem that we hear in the news on a regular basis, that contractors would have performed jobs and they're not paid by the public body. So at this time, what we would require is that you as the internal auditor verify from your finance person that the funding, or there should be some validation by the finance department prior to the procurement activity beginning, that the funding is available for this particular activity. You must verify the procurement activity that is approved. So within your organization, whatever the authorities are that approve your procurement based on the dollar value, you should see those signatories there. Verify the written justification for each procurement. So each activity must have a justification. And you verify that the procurement activity is aligned to the needs of the organization. So you should not be procuring things that are outside of your review or outside of the scope of what that public body's function is. Then we will look at the tendering process. When we look at the tendering process, we must look at as the internal auditor, we must look at the award criteria in terms of when we prepare each procurement activity. We must also look at the weightings and the scoring method that are appropriate for the procurement activity. Verify the award criteria issued in the solicitation package matches the award criteria used in the evaluation sheet. Verify exemptions of the award criteria were justified and documented. So for instance, let's just say when we set out the award criteria, we say that the commercial package will be at a 30% and the technical will be at the 70%. When we outline what those particular criteria are, we would say, for instance, in outlining the criteria, the evaluation criteria, or how the contracting authority will assess which bids best suit the response of the requirements. So for an example, we will say an example of an evaluation criteria, the product or services is fit for purpose. Or we will say the supplier is required to provide support activity for the entire life cycle of the procurement. When we're looking at the weighting and the scoring, we shouldn't decide what the scoring and the weighting is after we receive those bids. We should, when we are doing the procurement document or we are engaging the supplier or the contractor, we should already know, and the suppliers as well should already know what those scoring and what the scoring methodology will be that we'll be using. We should also, in terms of when we're verifying the criteria and the scores that have been allocated for this procurement activity, as the internal auditor, we should ensure that the information there is accurate in terms of the calculation is accurate. We should ensure that, let's just say, for instance, when we say one of the criteria is the procurement, the experience, the amount of experience that a procuring entity, a supplier or contractor should have. And then when we weigh that as 20%. And when we're looking at the overall experience of the company, we weight a factor that would have been included in that previous criteria into the evaluation of another criteria. So in essence, we're double counting. And we should keep those scoring criteria very separate and very clear, and it should be known at the start of the procurement activity. Another factor when we're auditing the process using the handbooks and guidelines, we should, again, the weighting here, we speak about the evaluation and the weighting. Each component should be appropriately weighted and scored by all bidders. The overall weighting and scoring for these bids were correctly calculated, and the notification of award is issued in writing. So Delrene would have spoken to the standstill period, and this is where the standstill period comes in, that when we notify public bodies, or suppliers and contractors notify public bodies of the successful proponent, we have this standstill period happening. Then we have the contract and closeout. So again, the auditor plays a very important role here when we're looking at procurement or procurement that would have happened in the past. We must verify the delivery of goods and services. When we say we verify the delivery of goods and services, so the procurement would have most likely happened already. How are we going to verify the quantity, the quality, the time stipulated, and the price? There should be some document trail, some signing. The procurement officer is now responsible for ensuring that whatever goods or services that were supposed to be delivered to the public body were in fact delivered. The quantity, the quality. Procurement officers are now required to go on to what Delrene would have spoken to in terms of the database and rate a supplier or contractor in terms of what sort of service are they providing. And this will help in terms of other public bodies looking at suppliers and contractors to provide goods and services. And upon the closeout of the contract, financial securities should be released. So if it is that we held a security in terms of your bonds, your performance bond, your bid bonds, those things should be released. And the internal auditor plays a role in terms of ensuring that at the end, once all the criteria has been satisfied for procurement activity, that these financial securities are released. So how has COVID impacted the auditing function? And we say that there's a greater need for audit intervention at this time. In terms of, we have a lot of work from home. So we have things that are going through round robin. We have things that are not, we don't have the hard copy in front of us. So the internal auditor must have an early intervention in terms of the activities that are taking place. There's greater need for transparency. Again, because we are not in person, things are being signed via e-signature. So we have to look at those things. There's a greater need for sharing of data and recommendation, and greater need to follow up in terms of, again, inviting the audit function early. And the last slide is just to tell us in terms of, or the last two slides, what are the offenses and the penalties under this act. So we have, Mr. Lalchan always says that the act is not there to put people in jail, but to help us comply. But some of the penalties, if it is that your non-compliance, is for the first, under 14.2, failure to comply with a direction of the OPR issued under this act, summary conviction of up to 100,000. Sorry. Section 17.2, failure by a member of the board of the OPR to commit, who commits an offense in terms of the disclosure of the interest. There's a summary conviction of 500,000 and 1 year in prison. False report, 500,000, 1 year and 1 year in prison. For bribery, conflict of interest, corruption, fraudulent, collusive or coercive, obstructive practice, we have conviction of 1 million and 5 years in prison. And we'll go through these offenses and penalty, and you'll see that there is a financial penalty as well as a time penalty. So we don't want persons to breach the act. We just want you all to comply with the act. This other section here tells us again of the offenses, splitting of procurement, and what the penalties are: breaches of confidence, victimization, failure to report, collusion, concealing and destroying information. So again, I would have alluded to this earlier in terms of why it is important for the internal auditors to ensure that There is a paper trail and failure to comply with the requirements of the Act in terms of confidentiality in the challenge proceeding. And this will bring us to the end of the presentation. In terms of the road to full proclamation, the OPR has completed 98% of its recruitment. The procurement and the disposal of public property was laid in Parliament on July the 2nd, 2020. The date 2021, sorry. The database has been rolled out to all suppliers and contractors. We have presently on our website 41 handbooks and guidelines. A report of the Parliament Joint Select Committee on the Finance and Legal Affairs is available on the Parliament website, and the OPR's first stewardship report for the period 2018 to 2020 was submitted to Parliament and has been uploaded on our website. So at this point in time, I'll hand you all over again to Mr. Lalchan, and we will take any questions that you have regarding the presentation.
All right, thank you very much, Delrene and Sharda. If we go to the very first question that we received, and the question was, what exactly should be included in the procurement plan? If you look at the house under planning, the first handbook and guideline under planning is the development of the annual procurement plan. So we do have a handbook and guideline on the system. We did conduct a training session with a number of public bodies and named procurement officers. It's on YouTube on our website. So you can go straight to the YouTube section. What we will do, we'll post that link on the chat station, will post it. So you can go on that website, sit down at your own leisure time and look at the video in terms of how you develop the annual procurement plan, what are the constituents of the development, and also it gives you a step-by-step approach. We will be having another session coming up within the next 2 months as a follow-up session because of the number of requests we have been having. So that should answer the first question. It is on YouTube. We did have that session, and it's a step-by-step approach to the annual procurement plan. So far, we have gotten about 15 annual procurement plans to look at from the public sector. So that's the first question. The second question, does the Act also permit for the procurement entity to notify the supplier contractor if their submission for a contract was not accepted? The answer is yes. You are supposed to notify all the suppliers and contractors who participated in a procurement activity and actually send the information as to who was awarded. In fact, that becomes a public document now. And the contractor or supplier is in their right to ask for a review as to why their submission was not successful. And you have a right now under the Act to give them information as to the reasons why they have not been successful. So that also is part of what is required. The next question that came through, to clarify, the procurement process must include a standstill period between when the procurement activity is completed, that is the successful bidder selected awarded, and when the contract period begins. Is there a standstill recommended period for this? Yes, the recommended period is in keeping with international standard, and the standstill period is between a time of 10 and 15 days, depending on the nature of the procurement activities. You can select which one you want. And the standstill period starts at the point in time that you would have notified all the contractors and suppliers who participated in the process that you are about to award the contract to A at price B, and then the day zero starts at that point in time. And after 10 days or 15 days, as you so select, and there are no objections or no requests for review, then you can go ahead and award the contract. And thereafter, there is no room for any challenge proceedings after you have given that opportunity. That's one of the reasons why we have put in place the standstill period, to avoid any body coming after the fact that you have awarded the contract to make these frivolous claims. Road traffic offenses are not criminal offenses. Well, I could agree with that if someone says that, but we were worried about simple criminal offenses like the smoking of marijuana and minor offenses that are criminal offense that has nothing to do with procurement. And the other thing is that because this was open-ended, once you have been convicted of a criminal offense, you could not participate in public procurement, full stop, for the next 100 years. And we thought that if we are looking at restorative justice, we should take into consideration people's willingness to change, and therefore that's why we selected that period of 10 years. After 10 years, you could come back into the system and be a part in equal terms with other persons who participated in public procurement. Next question, will a supplier or the supplier contractor have the opportunity to be removed from the list if they can demonstrate that they have dealt with the factors which led them to be added to the list? The answer is yes. In fact, as part of the prerequisite, you, as a public body, you should have demonstrated that you gave the opportunity to the supplier or contractor to restore their bad behavior, to become a compliant contractor supplier. And failing to do that, then you report them to the office for consideration. They are also given an opportunity to be heard in terms of their removal and being placed on the ineligibility list. And once they have not been satisfactory in terms of their response, then they go on to the ineligibility list. For example, if somebody has been convicted of a criminal offense, or sorry, a offense like, let's say, corruption or corrupt practices and so on, and then you put them on the ineligibility list, and 2 months after they appeal, and the appeal is successful, then that is a reason for removing them from the ineligibility list and placing them back on the active list. So the answer is yes. All that is part of our procedures that we have developed to be rolled out shortly. Where there are no senior officers, should a company have TROs conduct procurement processes? Now, I'm not so sure what a TRO is. If someone could help us by typing in what a TRO is. Carla, if you could unmute your microphone, Carla, and explain to us what a TRO is, and we will be able to answer. Carla Matthews-Dutton. Or if you want, Carla, you can type in the, what is a TRO? And then we have how.
Hi.
Yeah, go ahead, Carla.
Training relief officer.
All right, so it doesn't matter what's the name of the person or the job description or position in terms of where they sit in the organization. In fact, some of the smaller organizations, especially things like the NGOs and so on, would not and may never have a full-time procurement officer. And we are suggesting that the person who is the named procurement officer could have other duties, because in some operation is not a full-time position. And therefore, by whatever name they are called, you must notify the office. But the answer is yes, they can fulfill the role as a procurement officer, and it does not have to be their full-time job, but they must be named as the procurement officer. So I hope that answers your question. And we are willing to assist in terms of upskilling. We have a number of training videos already on site, and we are about to put in place a learning management system that will upskill your persons who have been assigned as the named procurement officer. How can collusive price fixing and anti-competitive behavior be detected, or what evidence would suggest such? I'm sure the internal audit department is going to help us identify the collusive price fixing and so on. I could give you some examples in terms of what they do with price fixing. And for example, you have a number of what you call cartel behavior. And you share up the contracts in terms of company A gets it today, company B gets it tomorrow, company C gets it the next day, and the price is so abnormally high that it is worth the while to participate like a 1 in 4 or 1 in 3. And you get together and fix the price abnormally high, and the public body has no other alternative but to go with the lowest bid, which is abnormally high. But it's a collusive practice because of a monopoly situation with about a very few suppliers and contractors. I don't want to call the name of some of those, but we do have the name of some of those that has been taking place. And you can make some good guesses as to some of the suppliers and contractors who have been involved in it. some of the signs of possible bid rigging, and we would have sat down on a recent conference and these came up. Suppliers appear to be taking turns at winning tenders or sharing the contracts by value. Regular suppliers decline to tender for no obvious reasons. They'll use all sorts of spurious reasons why they can't. Bidders appear to deliberately include unacceptable terms in their tender, so you will automatically reject it because they put unacceptable terms or even terms that are so really unbelievable that you just ignore them. Bidders sometimes bid low and sometimes high on what appears to be the same type of supply, so that abnormally low bid, you pay particular attention and you just tell them, well, sorry, it's abnormally low, you can't fulfill that requirements, and of course you give them an opportunity to state their case. You become aware the bidder meet before the close of tender without you being present. So they sit down, they have some drinks in a particular restaurant that they all frequent after work and so on, and they have their panchayat. The winning firm regularly subcontracts to competitors that submitted higher tenders. So you bid today, and I subcontract to you tomorrow. So everybody benefits from the pie. One firm of professional advisors represents several of the business is submitting tenders. So the same person helps in the submission of the bids by putting together those bids and so on. So those are some of the behaviors that internationally we are aware of that takes place, and also in Trinidad. We do have some other questions. Those were the questions that came in before I logged in, but let me just pull up the other questions. Chat.
If you like, I can read them out for you, Mr. Lalchan.
And what are the current state of pre-qualification?
No,
proclamation.
Yeah.
So I did have a meeting the morning before the regulations was laid in Parliament 2 Fridays ago. The minister and I met, and he has given us a date of as soon as the new sitting of Parliament convenes, they propose to lay all the respective regulations, including the ones that you will have seen published, and then the regulations associated with the review board, the regulations associated with the disposal of real property is debated, and soon thereafter we should have a clear idea from Cabinet as to full proclamation. All things being equal, we should get it before the end of the year. So we are running out of time in terms of getting the public bodies prepared for that. Can you clarify that liaison role between the Internal Audit Department and the OPR? At what level will this be? Example, pass-through, request, coordinated response. One of the things that will happen is that although we have wide-ranging audit function to go into a public body and look for compliance, what we will be doing first of all as part of our process is to liaise with the Internal Audit Department through the accounting officer in terms of have they completed any audit in respect of the areas that we are looking for in compliance. And if they have done, we will be looking at those files. And if we are satisfied that the proper audit was completed, then we would not go into the full-scale audit, but just review the files. If we think there is a reason that we need to dig a little deeper, then we will do it. So routinely, we would expect the Internal Audit Department from the various public bodies to pass through their accounting officer and send us a copy of any audit that would have been completed in respect of procurement activities. And that's the extent of which we expect it to be done. And next question, can a representative expand on how the whistleblowing mechanism will work administratively? We do have a whistleblowing facility that has been set up. It's a firm out of Canada, and you can have 4 different ways in which you submit requests. I'll hand over to Sharda, and she is our single point accountability for whistleblowing. Everything flows through her because of her position in the organization. I don't see it until it goes through that whistleblowing facility. And if it requires my attention or any attention of any other officer, then it's brought to our attention. But it's like a Chinese wall between the Internal Audit Department and the rest of the organization. So Sharda?
So good morning again. So for the whistleblowing aspect, the OPR has set up what we call a case management solution and a whistleblowing solution. Persons can call into the whistleblowing number. The number is it's an anonymous. You call in, you can either make a report anonymously, or you can leave your name and you can leave your contact information. If you don't want to do so, that's also acceptable. The information is passed on to the OPR from the Canadian body to us at the OPR. And we will go through the process in terms of when a complaint or when somebody wants to blow the whistle in terms of a procurement activity, and we will do the necessary checks in terms of to see if there is any merit in terms of that particular activity. You can also send an email, so the option of emailing is also available. And you can also, again, call the number. You can call via TSTT. The number is a toll-free number. So those are the options that are available for you to make that whistleblowing case.
And we are just about in the next couple of weeks, once we have full proclamation, you would see a number of public advisories. We'll have a public campaign in terms of educating the public in terms of how they can bring forward complaints and requests for investigations and so on. Are there any mechanisms established which can assist in identifying persons who may legally change their names and establish new companies to get away from being detected? The answer is yes, and we have established relationship with, for example, like the company registry to look at names and so on, and this organization that money laundering.
FIU.
And we have had meetings with the FIU, the police commissioners, and so on, and the Attorney General's office, and so on. So all those will be followed through in terms of memorandum of agreement. The quick answer to that is that we will never be able to fully probably find all the culprits, but when they are found, they will be dealt with. Good morning, I chose to access. I observed that the purchasing officer may be part of the disposal committee and the head of finance is part of the PDAC due to appropriate segregation of duties. Can any of these be appointed as the procurement officers? If they are the procurement officers, they cannot participate in the committee as a PDAC officer. So you must have separation and segregation of duty. They can't fulfill two positions, like for example, be the procurement officer and also be the head of finance who participates in the PDAC. You have to have an alternative in the PDAC, and under regulations, the PDAC is not being embedded in the regulations. You can actually bring in someone from outside your organization to sit on the PDAC of a sister company or a sister ministry and so on. So all that is permitted to take place in terms of if you don't have the necessary complement or experience within your organization, you can bring in those persons. Remember, the PDAC is there, and it's a lot of the high risk, high value that will really go through the PDAC. Not everything goes through PDAC. Has the process outlined by the OPR with respect to disposal of public property been approved by the current Act? Has the process outlined by the OPR with respect to disposal of public property been approved? There is a new addition that was amended to either 2016 or 2017 under section 57A. You can look at that in terms of solidifying the real property and so on. It's 57A under the new Act.
But as real property, I think this is public property, like personal property.
Personal property has always been in the Act. And it deals with the disposal of personal property in terms of equipment and stores and equipment, I believe it is. Under part 6 of the Act, disposal of stores and equipment of a public body. You can see there on disposal of stores and equipment, part 6 of the Act. And we will be issuing the guidelines, and we have issued guidelines in terms of how you go about doing that. Can you outline which part of the Act has been proclaimed and are currently being enforced? You can look at legal notice number 150, volume 54, and you can see it on the screen there. Offhand, I could tell you the parts that we have enforced is the actual issuing of handbooks and guidelines. That has been proclaimed, and we have issued those 41 handbooks and guidelines. So that has been proclaimed, and you could look at the parts to deal with the setting up of the office and so on, those were actually proclaimed. But you can go through it in detail there. With regards to the bill of quantities estimates for construction contract, is there a benchmark industry average list to compare prices quoted? We don't have that right now, but most likely you'll have to check probably the Contractors Association, and I'm sure different agencies will have it, but often I can't say we have it in our database. While ZHAC has not yet been fully proclaimed, most of the requirements are above and beyond the requirements of the existing legislation. Hence, they can be implemented in advance of the proclamation. Are there any sections of the new act that should not be implemented by public bodies at this time, possibly due to the conflict with the existing legislation? Basically, the SEB manual and the Central Tenders Board is still in operation. So if there is a conflict between the Central Tenders Board and the present act, you follow the Central Tenders Board and the SEB. However, a lot of the public bodies and ministries have already started using the new legislation. I'll give you two examples, so just you are aware. TNTEC and Heritage Petroleum, we are aware that they have been following the new act. A number of ministries have been following it, notwithstanding, because the new act is just good practice. And therefore, a lot of persons have decided to implement it as much as they can implement it because it's just good practice. Next one, that was Kevin Padmo. Yeah. Does OPR have a specific email or help desk? We will send that in the chat. And there is a help desk. We also have a FAQ. So if you have a question, you could go to the FAQ section and it helps you in terms of the FAQs. And Stacia will also send those links to you. I think that was the last question, and we're right on cue at 11 o'clock. If you do have any questions, please feel free to send it through our feedback mechanism. We will have had all the links posted, so feel free, and this particular presentation will be shared by all participants through the Institute of Internal Auditors. So that brings us to the end. Let me take the opportunity once again to thank you for the opportunity to serve you. It's always our privilege. There's one more question. Let me take this one, and then we'll hand over back to Justin.
All right.
The procurement plan has to be submitted to whom? It has to be submitted to the office. The list of procurement activities that supports the plan is the one that you send, because the procurement plan has figures and dollars in it. The procurement activities do not have dollars in it. It's six weeks after the passage of the national budget. Since audit and legal services, etc., were exempt from the act, but should they be exempt from the internal audit? That's a call for you, and definitely it may not be a procurement activity, but it is definitely an area that you should pay particular attention to. God help us, probably in the next couple of years to come, it will be reintroduced back into the act. And we'll see how that goes. But again, thanks very much. And let me just say again, as Sharda would have said, this is not about putting people in jail. This is about making a better country for all of us and leaving a long-term legacy for our children and our grandchildren to say, my dad or my granddad made a difference in this country by changing the dynamics after 58 years of bad practice. Thank you very much and have a great day. Justin?
Thank you. Thank you so much, Mr. Lalchan, Delrene, and Sharda. I think you know, your passion and experience about this topic definitely came through. So thanks for the informative session and for addressing each question that was posed. I'm sure the membership appreciated that. We had about 76 participants today, and I'm pretty sure that, you know, this presentation will help us with our understanding of the Act and how it should be applied so that we can ensure compliance and, as you said, really enhance our, you know, organization's values and processes. So we look forward to building on this relationship with the OPR, and we also look forward to future collaborations with you. As soon as we get the slides, we will share it with the membership as promised, and thanks a lot. Thanks a lot, team.